For 89 years, a $200 federal stamp quietly discouraged suppressor ownership. Today, that stamp is zero, and the legal earthquake is already underway nationwide now. This isn't just a discount, it's a trigger for constitutional litigation that could reshape the National Firearms Act, state bans, and your hearing protection options. If you want updates without the spin, like this video, subscribe to Gun and Gavel, and keep the notifications on for court developments each week. The National Firearms Act passed in 1934 and slapped a $200 tax on suppressor transfers, at a time when $200 equaled about $4,500 today, roughly. Supporters called it regulation, but the math tells the truth. All NFA stamps combined brought in only about $36 million per year federally nationwide overall. That revenue is less than what many mid-sized cities spend patching streets, which proves the stamp was never a serious funding mechanism at all anyway. It worked as a barrier, a paywall built into federal law, and for decades it kept ordinary buyers from challenging the scheme in court successfully. Congress just set the suppressor transfer stamp to zero in the so-called One Big Beautiful Bill. And that change breaks the old justification overnight, practically. A zero tax is not really a tax, it's simply a rule. And rules that burden arms now face the Supreme Court's toughest scrutiny possible. So this wasn't just saving you $200. It set off lawsuits, agency memos, and state-level panic, because everyone knows the ground shifted right under them. Right now, roughly 3 million suppressors are legally registered across 42 states, and that number has exploded even with the old stamp still required before. In 2012, the registry held about 285,000 suppressors, meaning ownership grew nearly tenfold in 12 years, despite the cost and wait for approval and paperwork. Analysts expect faster growth now because most suppressors already cost $400 to $2,000, and removing the extra $200 matters to middle-class buyers everywhere immediately too. Some market forecasts say purchases could double within 2 or 3 years. But the bigger change is happening in banned states right now in court. 8 states still ban suppressors outright: New Jersey, California, New York, Illinois, Massachusetts, Hawaii, Delaware, and Rhode Island. And lawsuits target them all at once. Those states relied on the federal tax structure as political cover. But with the stamp gone, their constitutional footing looks thinner by the day now. New Jersey is the focal point because a loss there becomes a blueprint, and attorneys general in other banned states know it very well already. Before we talk lawsuits, we need to correct the biggest myth. Suppressors do not make guns silent, and the numbers prove it every single time. A typical unsuppressed pistol shot is around 160 decibels, and permanent hearing damage starts at roughly 85 decibels for sustained exposure, according to health guidelines. A suppressor often reduces sound by 20 to 35 decibels, leaving many handguns still near 130 decibels, louder than jackhammers and audible for blocks away. That's why many experts treat suppressors as safety equipment, like better mufflers, because they reduce blast without erasing the report in any realistic outdoor setting. The CDC estimates about 17% of adults have some level of noise-induced hearing loss, and shooters are overrepresented in that group today as well. Among veterans, hearing loss is the most common disability, affecting more than 2 million former service members, and the VA spends over $1 billion yearly. With 3 million suppressors already owned by law-abiding civilians, courts will struggle to label them rare or unusual under modern Second Amendment tests at all. That phrase, common use, matters, because the Supreme Court has said arms in common lawful use receive protection, and suppressors now clearly qualify under Heller. So if you thought suppressors were only for spies, answer in the comments. Did you expect 130 decibels? Or did Hollywood fool you again too? Now here's the twist. For decades, you could buy a suppressor like any other product, with no stamp, no registry, and no waiting period either. Hiram Percy Maxim patented the first successful commercial suppressor in 1909 and sold the Maxim silencer through catalogs, including Sears, to hunters and target shooters. Early buyers were sportsmen who wanted less noise for neighbors and less damage to their own ears, not gangsters hunting victims in dark alleys downtown. Everything changed in 1934 when Congress responded to Prohibition-era violence and bundled suppressors into the NFA alongside machine guns and short barrels without much debate. Legislative records show little crime data about suppressors. What drove inclusion was fear, sensational headlines, and the belief that sound reduction equaled stealth for killers. That historical weakness mattered less while the NFA rested on its taxing power, because courts tolerated burdens framed as taxes even when punitive in practice. But the legal landscape changed in 2022 when New York State Rifle and Pistol Association v. Bruin replaced balancing tests with history and tradition analysis for guns. Then, in 2025, Congress removed the suppressor tax, and those two events collided, opening the cleanest legal window in generations for a direct challenge today. The leading state fight is Padua v. Platkin in New Jersey, brought by the Second Amendment Foundation, American Suppressor Association, and the NRA together there. Their argument starts with plain text. The right to keep and bear arms shall not be infringed, and suppressors are protected arms-related devices for use. At minimum, they say, suppressors are integral to using firearms safely, so banning them burdens the exercise of the protected right directly and substantially too. Under Bruin, New Jersey must point to a historical tradition of similar regulation from the founding era, roughly the 1790s or earlier American practice records. Suppressors didn't exist then, so modern public safety reasoning is not enough. The state needs an analog, not a policy memo or statistics alone today either. Plaintiffs also cite surprising support from within the federal executive branch, pointing to DOJ statements in other litigation that suppressors are protected items by text. That kind of admission is rare, and it gives judges permission to rule for gun owners without feeling like they're inventing doctrine from scratch today. Meanwhile, parallel lawsuits are active in Texas, Illinois, and California, forming a coordinated push, much like the strategy that built Heller and Bruin over years. In Texas, Gun Owners of America, Firearms Policy Coalition, and Silencer Shop are attacking federal NFA registration requirements, not just state bans in court directly. A win on registration could shake every NFA category, from short-barreled rifles to destructive devices, because the framework was built around tax collection as authority. New Jersey faces a two-front fight because FPC v. Platkin runs alongside Padua, pressing similar claims from different angles and timelines in federal court too. Supporters say this is the biggest coordinated Second Amendment offensive in years, and the timing is intentional, not accidental given the new legal standards now. A 2023 survey suggested about 1 in 8 gun owners, around 8 million Americans, either own a suppressor or are considering one right now seriously. Internationally, places like Finland, New Zealand, and the United Kingdom often treat suppressors as normal hunting gear, even encouraging them for hearing protection in practice. Combine global acceptance, millions of U.S. owners, a zero federal stamp, and Bruin's history test, and you get a uniquely favorable environment for rights claims. So answer this. Should residents of New Jersey and California have the same suppressor access as Texans and Floridians? Yes or no, and why exactly? Now, let's give critics their due, because police groups and gun control organizations raise arguments that sound plausible to people unfamiliar with decibel levels and physics. Their core claim is that quieter shots make it harder to locate an attacker during a shooting, reducing response time for officers and bystanders nearby. States defending bans lean heavily on that narrative, but courts will ask for evidence, and the evidence base for suppressor crime is tiny in practice. A Congressional Research Service review found suppressors involved in fewer than 30 modern federal cases, while hundreds of thousands of violent gun cases existed overall. That works out to roughly 0.01%, meaning criminals overwhelmingly choose stolen guns, illegal conversions, or entirely different weapons rather than stamp suppressors for violence. The FBI's crime data doesn't show suppressors as a meaningful driver of homicide, robbery, or assaults, and prosecutors rarely see them in ordinary case files. Even if a concern sounds logical, Bruin says modern cost-benefit policy balancing is not the constitutional test. History is the only required measure now today. That creates a hard reality for ban states. A persuasive safety story is not enough if they cannot identify a founding-era analog for this device. So the question becomes not, is it safer, but did Americans in 1791 regulate comparable arms accessories in similar ways through bans or permits then? Now let's move into the court calendars, because procedure is being used as a weapon, and one recent order in New Jersey matters a lot. In Padua, the state asked to slow briefing and stretch timelines, essentially hoping delay would drain momentum and resources from plaintiffs over months or years. The judge refused to pause the schedule, which is a small procedural ruling with a big signal. The merits will be examined in open court. New Jersey's defense has leaned on standing, ripeness, and pleading technicalities, trying to win without ever defending the ban under Bruin on history grounds alone. When a state fights the question instead of the facts, it often suggests they know the historical record cannot support their position very well either. At the same time, FPC's parallel case keeps pressure on, preventing New Jersey from bottling everything into one procedural choke point for escape or delay. In Texas, the federal challenges ask an even bigger question. If the stamp is zero, what constitutional authority justifies mandatory registration under Article 1 today? And there's a wild card. Will the Justice Department file an amicus brief supporting plaintiffs, as it hinted in prior Second Amendment litigation soon here? If the federal government sides with challengers, banned states would be fighting both national gun rights organizations and Washington at the same time in their courts. That combination could accelerate rulings and increase pressure for settlements, because states rarely want to lose in a precedent-setting opinion that spreads nationwide fast afterward. Zooming out, the NFA regulates machine guns, short-barreled rifles, short-barreled shotguns, suppressors, and destructive devices, all tied to the same registry logic since 1934 originally. If courts say registration can't stand without a real tax, the entire framework becomes vulnerable, including about 750,000 registered short-barreled rifles in that database today. That would be the largest collapse of federal gun regulation since the NFA's birth, and Congress would face pressure to rewrite everything from both sides. On the state side, if New Jersey loses, the precedent becomes a roadmap for California, New York, Illinois, Massachusetts, Hawaii, Delaware, and Rhode Island. Those attorneys general are watching closely, and many are drafting contingency plans for what happens if courts order them to allow suppressors for civilian ownership. America has about 100 million gun owners, and polls suggest roughly 40 million have expressed interest in owning a suppressor someday if legal easier. Yet only about 3 million are registered, which shows how much demand was suppressed by the stamp, the weight, and state prohibitions for nearly decades. If those barriers fall together, the firearms market changes, the hearing protection conversation changes, and the political fight over accessories intensifies within one generation of voters. So what should gun owners do right now? First, know your state law, because a federal change doesn't automatically lift state bans or local restrictions. Second, track the cases, because the first appellate ruling on suppressor bans will influence every other judge who faces the same question next year too. Third, don't fall for myths. Suppressors don't create movie silence, and courts are being asked to judge rights, not fiction or scary sound bites online either. Opponents will keep repeating that suppressors hide murders, but the data shows criminal use is vanishingly rare compared with overall gun crime in America today. Supporters will keep emphasizing hearing protection and common use, and they will point to the millions already owned without any crime wave linked to them. The courtroom fight will hinge on history. Did the founding generation ban safety-enhancing arms components, or did they generally allow citizens to equip arms freely? And it will hinge on definitions. Are suppressors arms, accessories, or something in between? And how closely are they tied to protected use for self-defense? Expect judges to ask whether banning suppressors is like banning ammunition, magazines, or holsters, all of which directly affect how a firearm is born daily. Expect states to argue that suppressors are uniquely dangerous, and expect plaintiffs to answer that they are uniquely protective for hearing and situational awareness too. Also expect industry growth if bans fall, because more lawful ownership means more training, more range use, and more normalization of safer practices over time. But none of that guarantees an easy win. Courts move slowly, and states can appeal, stall, and seek emergency stays when they sense defeat coming. The next 6 to 12 months will be decisive, because early rulings on injunctions will signal whether judges view bans as likely unconstitutional under Bruin. If injunctions issue, sales will surge in legal states, and political pressure will rise in ban states as residents watch others buy what they cannot. If injunctions are denied, plaintiffs will appeal, and the First Circuit split could set up Supreme Court review with enormous implications for NFA items again. Either way, the end of the stamp removed a political fig leaf, and it forced courts to confront the NFA as pure gun regulation alone. And pure regulation must now justify itself under the Second Amendment, not under the tax code, which is why this moment is historic for everyone. If you're in a ban state, stay informed and avoid shortcuts. Do not try to import, build, or possess a suppressor illegally while cases proceed. If you're in a legal state, remember that transfer rules still apply until federal registration is changed by courts or Congress, and patience matters too. Most importantly, watch New Jersey, because Padua and FPC could generate the first opinion that other states must answer, and it will be cited everywhere. This is not about gadgets. It is about whether government can use paperwork and delays to ration constitutional rights to the wealthy only forever again. If you want me to cover each court filing as it drops, subscribe to Gun and Gavel, hit like, and share this with a buddy. Drop a comment with your state and whether you think suppressors are safety tools or public threats, because the courts will read the culture too. The $200 wall is gone. The lawsuits are moving, and the next ruling could change American gun law for decades, so stay alert from here.